Well, I think we're just about ready to begin. Welcome, everyone. The title to this program is The Duty to Bargain During the COVID-19 Pandemic. My name is Esther Bigler, and I direct the Cornell ILR Labor and Employment Law Program. Unionized employers generally cannot make unilateral changes in wages, hours, and working conditions without bargaining with the union. However, employers and unions are facing an unprecedented situation as they deal with COVID-19. New and frequently changing guidance issued by CDC, the EEOC, OSHA, orders by local and state governments have necessitated decisions about layoffs, furloughs, changes in working conditions, hours, health and safety requirements, reopening, closing again. On March 27th, NLRB General Counsel Peter Robb issued GC Memo 2004, summarizing case law on exigent circumstances that may allow for the employer to make changes without bargaining with the unions representing its employees. Unlike other GC memos, this memo summarizes the law but does not tell us how the GC will rule on certain cases. We will be discussing this today. This is a New York State CLE program, continuing legal education. Please be patient about getting your CLE certificates. We will send them to you as soon as we get them from the Cornell Law School. They are actually the grantor of the CLEs. To ask questions, please use the Q&A box at the bottom of your screen. We will be putting links to the program evaluation and materials in the chat box. In addition, some point during the program, I will announce and show you the special CLE code that you must put on your evaluation. Our speakers today are Allison Beloved, Karen Fernbach, and Michael Lebovich. Let me introduce you to our speakers. Allison is a partner at Levy-Ratner. She has devoted her career to protecting and advancing the rights of working people by representing labor unions and individuals in all aspects of labor and employment law. She litigates cases in state and federal courts, as well as at the NLRB, the EEOC, the New York State Division of Human Rights, etc. She uses her skill to help clients navigate discipline and contract interpretation cases at the AAA and JAMS. She has substantial experience negotiating collective bargaining agreements covering thousands of workers. She represents unions in a wide variety of industries, including healthcare, utilities, cultural organizations, legal services, sports, maritime, education, and the Postal Service. She's also the chapter editor of the seminal labor law publication, Developing Labor Law. Karen Fernbach is a visiting assistant professor at Hofstra Law School, where she teaches at the Maurice Dean School of Law. She has held this position since retiring in 2017 as Regional Director of Region 2 of the NLRB, where she oversaw many high-profile and complicated cases. Ms. Fernbach teaches labor law, employment law, collective bargaining, and advanced topics in labor and employment law, and an externship seminar. She is also the co-advisor for the Hofstra University Journal of Labor and Employment Law. She was appointed a labor arbitrator by the American Arbitration Association in 2019 and finds time to teach labor law as an adjunct professor at her alma mater, St. John's University School of Law. She was elected by her peers to be a member of the College of Labor and Employment Lawyers. Michael Lebovich is a partner in the Labor and Employment Law Department and co-head of Labor Management Relations Group at Proskauer Rose. He represents and counsels employers on a wide range of labor and employment matters with particular interest in the field of traditional labor law. He acts as the primary spokesperson in collective bargaining negotiations, regularly handling grievance arbitrations, assists clients in labor implications of corporate transactions, and counsels clients on union organizing, strike preparation, and day-to-day contract administration. He also has significant experience in representation in ULP cases before the NLRB. He has substantial experience in a wide variety of industries, including entertainment, broadcasting, newspaper publishing, delivery, utilities, and lodging. All of our speakers have been very involved in presenting in many different forums, including here at Cornell and also at the ABA, the New York State Bar Association, the City Bar, etc. So now I would like to really turn to our program. Karen, to start us off, could you give us some context for our discussion today? Please give us a summary of the GC's memo and the information he wants employers and unions to consider in this pandemic.
Sure. Thank you, Esther, and thank you for that lovely introduction. One of the things that I found interesting was the memo, because it really doesn't provide guidance. It provides case summaries, as you said, but just to take a step back, what is it that the General Counsel is saying is that we are going to have many issues, and he issued this March 27th, which was the beginning really of the COVID pandemic in the United States, or maybe it was in February, that's a different issue. But in any event, he wanted people to, employers and unions to think about the obligation to bargain over changes when they relate to terms and conditions of employment. As you may know, many of you, I'm sure on this, are labor lawyers or have taken labor courses. Any change that is not encompassed by the contract, the collective bargaining agreement, any change in terms and conditions of employment, when you have a collective bargaining relationship, you must, if they are substantial, you must, and also a material change, you have an obligation to bargain with the union on both the decision and the effects. Now, there are exceptions, and these exceptions are very rare. And so the question is, what are the exceptions? Now, the General Counsel has put together case summaries citing what the main cases, frankly. He cited a few cases, but the actual law is encompassed in two decisions, Bottom Line Enterprises and also RBBE, where those were cases which set forth what would permit an employer to make unilateral changes, and it was very limited. And the RBE, the actual decisions, bottom line is at 302 NLRB 373 1991, and there it's an exception where the employer can demonstrate economic exigencies compelling prompt action. Now that doesn't necessarily say very much, so we have to look at some of the cases. What they say here is that it has to be extraordinary events, which are, and I'm reading from the memo, which are an unforeseen occurrence having a major economic effect, requiring the company to take immediate action. And they cite to the second case, which is RBBE Electronics, which is found at 320 NLRB number 81, NLRB 80, 1995. And there, again, the board put limits on what is an exigent circumstance. In many cases that are cited, they conclude, the board, that it's not going to be a defense to making unilateral changes. What are the ones that maybe you would be permitted to do a unilateral change? If there's a hurricane, maybe. Something that is not necessarily going to be, it's unforeseen. So, and in these cases, there's a few here that are cited, which you could look at, where they conclude in one case that the mandatory evacuation due to a hurricane in court printing and specialties, where they didn't have actually a existing collective bargaining agreement and they had to lay people off because there was a mandatory evacuation. There, they concluded that the exception was okay because they didn't have any choice. But in many of these cases are not really applicable to the current situation because COVID is not a one-day affair. The COVID pandemic is an ongoing problem, and we're constantly getting different communications from from, as Esther said, from the EEOC, from OSHA. What can an employer do? Should they be able to, for example, should they have to bargain with the union if they're going to require all employees to take the COVID test? Probably the answer is you have to look to the CDC, which says that you are permitted to require tests. But does that mean that the union should have no input? When do you take the tests? Should they be able to bargain, even if you have a right to make the decision on your own? Don't they still have an obligation to bargain over the effects? What's going to happen if somebody fails the COVID test? What should the union and the employer be making? They should be making determinations. When do they come back to work? So these are decisions that are actually constantly changing. And it's really hard to give advice as to when the employer would be permitted on its own. If it was mandated by the law, then that would be okay. It would be okay for them to make, they'd have no choice but to make the decision unilaterally, but of course they still have to bargain over the effects. So interestingly, 2 days ago, as I'm preparing for this, sure enough, we have advice memos that issued regarding some of the cases that were submitted to advice during this COVID period that we're dealing with, and whether or not these changes that the employer was making were unilateral changes. Before we get to these advice cases, which give us some insight into how the general counsel is going to rule, not just setting forth the memo itself, we need to understand the law has changed in 2019 in terms of looking at, we have to decide, first of all, whether or not the change is a unilateral change. So, for example, there's a new case called MV Transportation. Used to be that if the employer had made some change that was not specifically covered by the contract, then there was this clear and unmistakable waiver analysis, and which would almost always require the union and the employer to bargain over the change. However, the decision in this MV Transportation, which issued, concluded that the general counsel reversed prior law and said, no, unilateral changes that are arguably covered by the contract and a reasonable interpretation will not be deemed unilateral changes, and therefore there's no obligation to bargain. That puts the union in a difficult situation, in my view, because they are relying on management rights clauses. For example, if you're going to lay people off under COVID and you have a very strong management rights clause, which previously was not as significant, perhaps, because of the clear and unmistakable waiver. But if now you're going to lay people off, the employer might argue it's not a unilateral change because we have a very strong layoff provision. And so that's a problem now. So these are defenses that the employer, a problem for the union in any event. These are defenses that the employer can rely on. A, it's required under the law, whether it's mandatory. B, it's covered by the contract anyway. I don't have to bargain over it. And C, which the employer is going to argue, under the RBE, it's an emergency. And so I don't even have an obligation to bargain over the decision. You may still have an obligation to bargain over the effects. And so these are like three defenses, and the way I read it, and I'm looking at recent advice memos, and I found out the reason these issued is because of FOIA. Because so the names are left out, except I want to just tell you about three cases that I think are very relevant to the obligation by the employer to bargain with the union or not. The first one that I thought was interesting was and they are listed. You can see them on, you can get them from the website, or they were in the 360 employment. So in any event, this case that I want to talk about, Children's School Services, came out of Region 5, and it issued June 30th of this year. And the question was layoffs that were, the employer argued that these were layoffs. It was that they claimed it was a government contractor that supplied nursing services within the DC public schools, and they claimed that they did not have to bargain over the layoffs. And these were layoffs because of the COVID issue. And so what happened, the employer cited that it was privileged to make the layoffs based on MV transportation. They were temporary layoffs, and the decision to lay off the nurses while the school was out was in the compass or scope of the contract provisions. Number two, they relied on a broad zipper clause, which I think is a problem for unions now, because they better not agree to broad zipper clauses, because the zipper clause, they say, foreclose the obligation to even engage in effects bargaining. The contract, yes?
Karen, can we hold the rest of this discussion so that we can go on with some more questions and come back to this at a later time?
Sure. But anyway, you can find these cases, these advice cases, they were just issued. Okay.
Thank you, Karen. Allison, I'd like to turn to you now. The world has changed. We are now living in a totally new environment. And yes, as Karen's been educating us, there certainly is a general duty to meet and discuss and confer under the law, even in the context of a pandemic. But now we seem to be in this new world of remote bargaining. Could you discuss for us the practicalities and challenges of virtual bargaining, and add to that, what happens when one of the parties refuses to engage in Zoom bargaining?
Sure, thanks, Esta, and thank you for having me here. The Section 8D of the NLRA requires that the parties meet at reasonable times and confer in good faith. It doesn't specifically require the parties to meet in person, but I think all of us who have engaged in the bargaining process think of it as getting together in a room around a conference table, passing proposals back and forth, and engaging in face-to-face discussions. And so this pandemic that we've been living with for the last several months has really raised the question of, are in-person bargaining sessions required by the National Labor Relations Act? Can a party refuse to engage in remote bargaining or not? The Act certainly doesn't specifically explicitly require in-person bargaining. It just says the parties have to meet at reasonable times. There are some old board decisions that address the issue of in-person bargaining versus, in these cases, it was telephonic bargaining. The cases, they mostly arise in the context of a union wanting to have in-person meetings and an employer saying, no, we're not going to come and meet in person. We can do this telephonically. The union files an unfair labor practice charge. And in those cases, the board has generally held that the employer can't insist on telephonic bargaining if the union wants in-person bargaining, and that the duty to meet at reasonable times really does obligate the employer to come and bargain with the union in person. It's a very different, those set of circumstances that we're dealing with right now. And so there really is the question is, does it violate the act for one of the parties, let's say the employer, to refuse to engage in remote bargaining via telephone or video conference when it's not safe to gather together as a group? And I would argue yes. And I'm actually dealing with a case right now where an employer, I represent a union, and it started bargaining with an employer for a first contract prior to the onset of COVID-19. We had a number of bargaining sessions. The parties had a hiatus starting in March when the pandemic really hit. And since late April, the union's been asking the employer to come back to the table through remote bargaining. And the employer has been taking the position, nope, we'll resume bargaining when it's safe to get together in person again. And we've filed a charge. The charge is pending. I don't know what the outcome of that is going to be, but I certainly think that while it may have been true in March when this thing first hit, and most of us, or certainly, I don't want to speak for everyone, but certainly I had no anticipation that this was going to go on for as long as it has. I thought we were talking about a few weeks and then we'd all be back to normal again. And maybe then an employer would be privileged to say, we're not going to do this over video conference. We're going to wait until we can get together in the room. At this point, this is 5 months and counting. And I think it would be hard, an employer's going to be hard pressed to argue that they're meeting their obligation to meet at reasonable times and confer in good faith when they're just refusing to engage in the only safe way of negotiating at this point, which is virtual negotiations. So we'll see what the region does with my charge, and there may be other charges pending out there. And ultimately, we may see what this board will do with that. I don't know, but we'll see. In terms of the practicalities of remote bargaining, I've been doing a lot of it over the last few months. Some people call it virtual bargaining, and I have a real issue with that because we are actually bargaining. And we are not virtually bargaining, we are really bargaining. We're just doing it remotely. I've used various platforms, Zoom, RingCentral, Google Meet, Microsoft Teams. They all have different idiosyncrasies and pros and cons, but I've used them all. And I guess I would say my takeaway from the whole process has been, yes, in-person bargaining is absolutely preferable to remote bargaining. But if remote bargaining is your only option, it's doable. And I've certainly been recommending to my clients that they embrace it rather than put off bargaining until a time when we can meet in person again. And the clients that have been using it have been finding it to be generally effective. Just to talk about some of the challenges about it from a union's perspective and a worker's perspective, I think the main drawback is that you don't physically get to sit in a room across the table from your bosses. For unions and for workers in particular, bargaining is a very empowering process. You get to bring your bosses into a room with you, make them sit at a table with you, listen to your demands, and have to face you and respond to that. And that's a really powerful thing for workers, and something is lost in workers' ability to come together because now everyone's isolated in their own individual spaces. And something is lost when you're not face to face with your bosses, but you're talking through a computer screen. And I also wonder whether it's easier for employers to say no to union demands when they're not in the room with the workers that they have to see every day at the workplace. I think when you are in a room with your workers who are telling you, this is really important to us, this is what we need, this is why we want it, it's harder to say no. But if you are doing it across the computer screen and you don't really have to look your workers in the eye, it might be easier to say no. So I think there's something lost there. Unions have had to get thoughtful and creative about how to make remote bargaining similarly effective and empowering, and how to hold management similarly accountable for their decisions. And it's doable, but there are certainly challenges associated with that. There are other challenges to remote bargaining that are equally applicable to unions and to management. I think it's harder to have longer sessions over remote bargaining. I've experienced that. I think people's stamina and endurance just isn't the same for some reason over the computer, whether it's because there's other distractions going on at home or it's just harder to do it. So, my experience in bargaining is that a lot of the times when things get really productive and when you get to a deal is after a marathon bargaining session, sometimes in the middle of the night. That's not happening generally over remote bargaining. It's harder to have sidebars and off the record conversations. And a lot of these platforms have breakout rooms and there's technologically the ability to do it, but it's not the same as sort of pulling counsel out in the hallway and really trying to get down to the bottom of what's keeping the parties apart and how to get to a deal. It's harder to exchange proposals. You have to sort of be a little bit more proactive and advanced thinking about that, because you can't just sort of toss proposals across the table because there is no table. And it's harder, harder to read the room. It's harder to deal with nonverbal cues that we normally do when you're in person. And I guess, for lawyers, and I think most of us tend to be control freaks. I certainly am. It's harder to have control over your clients and what they're doing in the room. You can't kick them under the table. You can't really shoot them the look of like, stop talking now, which sometimes you want to do. And that comes with its own challenges. There's a difference, I think, between situations where you've had a long-standing collective bargaining relationship with the other side, and there's a built-up history of trust, or at least, if not trust, at least a built-up history, so you know where you stand, versus negotiating a first contract with parties that are virtual strangers. I will say, however, before I turn it over to Michael to talk, that he and I recently negotiated a first contract via Zoom. And at least from my perspective, I think it went about as well as it could have gone. And I was thinking about why that was, like, why was it successful? And I think for me, my opinion at least, and I'd be curious to know what Michael has to say about it, I think we were lucky enough to have had several in-person sessions before going into the remote bargaining, so that, while our relationship was still very new, there was at least some experience with each other. So we didn't feel quite like strangers when we got onto the Zoom. And I think most importantly is that it was parties that were both committed to reaching an agreement and committed to making the remote bargaining process work. And without those two things, I think it can become very quickly a disaster. So that's really what I have to say about it. And I'm happy to turn it over at this point.
Michael, I'd like you to respond to Allison and add something in addition. So I am certainly interested in getting your perspective as a management lawyer about remote bargaining, and especially the fact that the two of you had already had a relationship when you sat down to remote bargaining. And that would be different in a first bargaining situation. But also, if you could then expand what you're talking about a little bit to talk to us about what are the best practices for preparing for bargaining and implementing a whole bargaining strategy. And in your view, given how unsettled this whole area is about unilateral changes, given the pandemic, when should you reach out to the union to discuss issues? I know I'm asking you two very different questions.
That's a lot, but I think I can put it together.
Good.
So the first thing I want to say is that almost everything that Allison said about the difficulties and challenges that come from a remote bargaining. I agree with Allison, even to the point that I don't like people calling it virtual, right? I mean, it's remote. We are negotiating, and it's funny because the general counsel, we talked a little bit about, Karen talked about the advice division of advice coming out with memos. There was actually a memo that came out in 2003 where it was a similar issue to the telephone cases, but it was somebody wanted to do video conferencing, and it was an employer who didn't want to fly down to Florida, which in 2003, they had different reasons for not wanting to fly down to Florida. Today, who knows? It's a case called United Restoration. And the general counsel at that time said, no, employer, you got to go do face-to-face bargaining because of things like face-to-face bargaining. Only in face-to-face bargaining can the parties observe nuances of eye contact and body language, not only part of the individual speaking, but also on the part of those observing. And it goes on and on all the reasons why trying to do something by video conference is difficult and shouldn't be the way you should do negotiations. And then COVID happens, right? And just like every other aspect of our lives, when March 5th, 12th, 13th, 14th, 15th came along, at least in the New York area, everything changed. And we had to adapt. And I think I got employers who have been completely willing to adopt to the process. And I have, just like Allison has counterparties that have difficulty doing it, I have unions where there are people who are refusing to sort of engage, and we need to deal with that. So to drive to the point that Allison was making about making a deal, how do you, sort of what's that like, right? Sort of to start there. I think the fact that parties that have a relationship, of course, the easiest part of that is it's easy enough to get on the phone and get on a video conference and talk to each other about how we're going to continue on the process we've already been involved in, right? So and I think that also highlights there's really two kinds of COVID area, maybe more, but at least two kinds of COVID area bargaining. There's the emergent, urgent bargaining that we've all needed to do and talk about. And there's that sort of one group that we need to address, whether it's financial exigency, whether it's safety and health, whether it's just some unique issue having to do with a particular employer. That's one area. And then the other area is continuing on our lives, being able to just negotiate the contracts that have been open, right? And so I've fortunately is probably the wrong word. That's what I've been doing both, right, along the way since March 12th, and had success in reaching both types of deals, agreements with unions over exigent circumstances in closed contracts, in open contracts, and having to make interim deals, and then also resolving final contracts. And I think the thing that makes it easy is if you are, as Allison said, if you are already down the road, right? You've already sort of figured out the cadence between the parties. You know how you exchange proposals. You figured that out. In that instance, you just can continue and sort of translate that on to the remote platform. The other circumstances are a little bit more complicated, and I'll get to that, I think, as to on your questions about when to reach out to the union. One of the things that I find from a practices perspective is, unlike other bargaining, look, you should always be prepared, right? You should always be prepared. You should always have authority. You should always be going into a meeting with when knowing what you want to do. That said, not being prepared for remote bargaining can be a disaster, right? Because you need you can't do the prep work in a 2-hour caucus in your other room. It just doesn't work because the other side doesn't have the 2 hours. They're not going to use that time usefully. You really need to set up your schedule in a way that you're thinking about. And let's face it, we're all, many of us here are labor professionals. We bargain all the time. A lot of times that first hour on the 9 to 10 bargaining session is for all of us to get our coffee and get our stuff and talk about what we did last time, right? That doesn't work, right? And it doesn't work because it just doesn't work because you're not in the same room, but it doesn't work because in the world we're living in right now, our clients have too many other things to do. The other side, people on the other side have too many things to do. People on the bargaining committee should be, they could be working and doing other things, or more importantly, taking care of their kids, their family, whatever the circumstance is. And so you really do need to be more prepared. You also need to have a system of exchanging proposals, which I think this is still a work in progress. Actually, I think I don't think we actually have this down. You're fighting a wave of about 80. The NLRB is 85 years old. We're fighting a wave of 85 years of history about how bargaining is done, right? I don't want to give you my proposals ahead of time. You don't want to give me your proposals ahead of time. But in this world, to get on the Zoom and then have everybody see each other and then send the email to the one person and then circulate it around, there's got to be better ways to do that, right? I'm pushing people, I haven't actually successfully done this yet, but I'm looking at trying to get unions to agree to sort of depositories, Google Dropbox, Google Drive, Dropbox, something that is a shared folder where all you have to do, and it only used for the purposes of exchanging proposals. You just drop it in, everybody else can see it. I've had it work a couple of times. People are very resistant on security issues and the like. So we have to work on that. But it's and the more you can do in advance, the better, right? So that's one practice. Again, so being ready, practice. And then I'm going to, again, sort of piggybacking on Allison, rethinking the schedule, right? You can't do an 8-hour bargaining session. It just doesn't work. You're exhausted, right? A 4-hour caucus or 2-hour caucus will exhaust you, and a 2-hour bargaining session will. My view, and again, this requires a kind of a mindset change, and it's taking time to get there, which is, I think you're better off a couple hours multiple times in the same week, for example, thinking about it that way. Meet Monday, Wednesday, Friday for 2 hours, do your caucusing in between, right? These are things to be thinking about when you're laying out the relationship. That's a very different way to bargain, right? Than most of us typically do. We typically meet, a lot of bargaining. You fly into a city and meet for 4 days, right? I have that in a lot of industries, a lot of multi-employer industries, example, and that's something we need to think about. The other thing I'll add is on caucusing. Caucusing is your own caucuses. It's extremely important, again, to be prepared and do that on to know and prepare when you're going into the bargaining session, because, as Ellison said, you can't kick somebody under the table. I often talk to my teams about, I'm the conductor. I don't know everything. I never will. I'm not the person I'm not the person there day to day. I'm here to help people make a deal. But I should know who should be talking. And that sometimes becomes complicated. You see, actually, you can't see right now, I'm moving my hands. Right now, I'm talking with my hands, but I'd have to be up here for me to see it. And it's very difficult to give those nonverbal clues in that circumstance, so you have to be prepared for it. I'm checking on the time, but I think I want to, just to quickly address one aspect of it, I'm sure we'll go into it in more detail, is, so when do you reach out? Right. And I think the answer to that is, obviously, the first question is, do you have to reach out? And to answer that question, you should be looking at, it depends on what circumstance you're in. Are we in a first contract, or do we have a closed contract? If you're in an open contract or a first contract, well, of course, you're going to be probably talking to the union about any changes that are going to happen, because there's no contract to rely on. If your contract allows you to, well, if you have as we're talking about MB transportation or if your contract allows you to, then you have to make that determination about whether you want to talk to the union about the decisions that have to come down the pike or not. My view, if we're talking about COVID-related issues, I don't think you can talk too much, right? You may reserve your rights. You may say you don't have to talk about things about certain health and safety or layoff issues. But I think if you're going to continue that relationship throughout, I think it's something you have to seriously consider about talking, being prepared to reach out to the union as much as you can. And I'm sure we'll talk more about that.
Thank you, Michael. When we were offline before we began, one of the issues that was raised in this issue of, one of the questions that was raised in this issue of, when do you talk to the union? When does management talk to you? And so I'm going to ask all three of you, and then we'll open it up to the group for questions. Should an employer or should the union ask for a joint labor management committee, a sort of COVID council, to begin thinking about issues that may come up? Because it may be that on a moment's notice, the governor tells you you have to close down and all the employees have to be laid off. Should that kind of a system be put in place? Would that help or hinder labor relations? Now, of course, I'm assuming a mature bargaining relationship here, not a new contract. So, Allison, I'm going to ask you first, then Karen, your view from your regional director head and your arbitrator head now, and then Michael, and then we'll open it up to the group for questions. Allison?
I mean, I'm probably not going to surprise anybody when I say the answer is it depends, right? I mean, it depends on, even in a mature relationship, it depends on the nature of the relationship. It depends upon what this committee is. I mean, I'm a fan of joint labor management committees when they are formulated with the right intent and with the right authority and with the right resources. am not a fan of sort of lip service labor management committees, which I have experienced employers willing to form labor management committees that have absolutely no teeth and no real authority to do anything. In which case the union, frankly, is better off sometimes not being part of the process. So I think, to the point that Mike raised earlier, when it comes to COVID, the parties can't talk enough. And I'm a subscriber to that. I really do think that the more communication between the union and management, between the workers and management, the better, because everybody in the workplace is affected by what's going on. It's not just the unionized workforce, it's everybody. And everyone should, has value to add to that process. So if these committees are formed with the right intent, I think they are a great way of trying to address these problems. I think they could save the parties from potential litigation down the road if there's no discussion and the employer does something unilaterally that it shouldn't have done. And where we can keep our clients out of litigation, that's good. That's my 2 cents.
Karen, you're muted. Karen, you're muted.
Okay, hi. In thinking about a best practice, it came to my mind that like they have safety committees, this is an extension of that. And what it would do from the employer's point of view, I think it's the right way to go. A COVID task force within the company with members from the union and maybe, shop stewards. What it does, first of all, is it gives the employer the opportunity to say, hey, I didn't do this unilaterally. It's a good way of, which is Allison's concern. If it's just, throwing it out there and then not listening to the committee, but it is a good way to communicate. And there may be things that you don't realize have an effect on your workers. And from the union's point of view, under the current situation, the way I see MV transportation, the way it's being interpreted in these advice memos, the emergency is seeming to be a valid defense to making these unilateral changes, and MV transportation and the zipper clauses. It seems that you really don't have very many options, but to try to get yourself in the middle of a bargaining discussion with the employer, whether or not they're going to agree with you. Litigation is the last place you want to be. These are quick decisions that have to be made.
Michael.
Yeah, so again, it's going to depend on the circumstances. I think it's going to depend on the industry. I think it's going to depend a lot on the safety issues that you're talking about, whether they're the general, we have office safety issues, whether we have specific industry related issues. And the reason I say that is because it's going to, I think the input that employees versus perhaps the union in a perspective could be limited. And it really will depend on the circumstances. I think that you always want to hear from your employees about their concerns, right? And you should be a complete, an open door in that regard. The ability to, from a committee perspective, it's really going to depend on whether the individuals on that committee have the knowledge, right? I mean, COVID is changing constantly, right? So I've actually found that my counterparts on the union side, very knowledgeable. They're hired the same, similar types of scientists that my clients have, right? And so what I mean by that is having those conversations with the input, with their thoughts. We have some disagreements on the science. We have disagreements on what the science, how it impacts the employees, and we're going to have those discussions. Whether the shop floor, for lack of a better word, to use the old school format, input, I question sometimes how much value that will have. I think it's important to give people a voice to hear their concerns, right? And as an input mechanism, but a decision-making mechanism, I think really is more likely to be either the employer, if they have those rights, or as in a bargaining perspective rather than in a committee perspective. Now, it could all depend on how those committees are structured, of course.
That I think is an area where Mike and I, we've mostly agreed, but there I think we have a substantial disagreement, because I think it is, the shop floor employees, the ones who are really doing the work, that actually they know what's going on and they do have real value to add. And what, the way Mike phrased it is really the concern that I have as a union advocate, which is that these committees are being used as an input mechanism only, just to give the appearance that employees are allowed to express those thoughts aren't really being considered by management. And I think that's a concern that I have generally with labor management committees, and particularly in the case of COVID.
Yeah, and just to be clear, I mean, obviously, I think people should take the input and use it. I mean, it's not not to just give people a voice to not use it. I think that creates other problems, right? And doing this every day, and Allison, I know you do this every day, dealing with what COVID means to the workplace. What we knew on March 12th is not what we know today. And it's not, in every industry is different and the like. And unfortunately, and this is not an experience that I've had with employees. I've actually had this, you can have this experience with your relatives, you can have this experience with your friends, the people who are in this day to day have a very different perspective than people who hear about it on the news or read one article or one, right? So you have to take input from everybody, and it has to be synthesized. So I think I have difficulty suggesting the idea that there should be one committee or one entity that has authority to act for an employer. I think the employer, not surprisingly, I'm the employer rep on the panel. I think the employer has to retain that authority because you need to be able to evaluate things and, frankly, constantly changing issues.
Well, I just want to say, I just want to throw one thing in. Even if you technically have the authority to make that final decision, you still have to bargain over the impact or the effects. And so it's also good for that purpose.
I don't disagree. I agree with that.
Absolutely, Karen. Okay, I want to turn to the audience because we've got some interesting questions in the chat box. So if the CBA has a force majeure clause, and given that in most cases the pandemic began in mid-March, do you believe it's too late for the employer to declare force majeure? And you should probably explain what that means for people who don't know. Michael, do you want to try that first?
Sure. So a force majeure clause is a provision in a collective bargaining agreement that says for certain reasons, and a lot of them say pandemic or act of God or act of nature, that the provisions of the collective bargaining agreement are not in effect, or they're suspended, or certain parts of the contract are suspended during the period of quote unquote force majeure. Whether or not so it's hard for me to answer that question because I don't know why you haven't invoked it yet. But let's assume for the sake of argument, maybe you got PPP money, right? And you were able to maintain, or you just had a rainy day fund, or you were able to keep people employed, and you had a guarantee, you had a job guarantee, because some contracts have job guarantees, and they also have force majeure clauses. Without, very hard to give any opinions without actually seeing contract language. But I would say I don't think it's too late, as a blanket statement to invoke that force majeure clause, and for a couple of reasons. A, there's probably a good, and more importantly, the next part is circumstances are constantly changing, right? I have this conversation in the hospitality industry a lot, right? We thought, the industry thought it'd be up, back up in April, May, June. Then we really thought it'd be up in July, and then June and July happened in Florida, California, and Texas. Things keep constantly changing, and I think you have to continue to evaluate your force majeure clauses as well as any other provisions that you have in your contract based on the current circumstances. And in the same way, all your practices, past practices, and the like, just like you look at evaluate that based on circumstances, I think you have to evaluate your force majeure clauses in that context as well.
Allison, would you like to add to that?
Yeah, I guess generally force majeure clauses are meant to deal with unforeseeable circumstances. And I think that at this point, again, we're like 5 months and counting into this pandemic situation. It's a hard argument to make that where we are right now is not foreseeable. The time to invoke the clause would have been at the beginning of this. I agree with Mike that circumstances are changing, and it could depend on where you are. But assuming we're in New York, things have gotten better, not worse, obviously, since March and April and May. And if someone were to invoke that clause now, I think they'd have a really hard time of it. And I think it also goes back to what Karen was talking about and the exigent circumstances exception to the prohibition on unilateral changes. That also is meant to deal with unforeseeable circumstances. I don't know what this board, would do. I don't have a whole lot of confidence, frankly, in what they would do. But, I think if we're staying true to what that exception is meant to do, it's supposed to be a narrow exception. It should apply to unforeseen or unforeseeable circumstances. And 5 months into a pandemic, it's a harder argument to make that we're dealing with something that's unforeseeable.
Karen, something to add? You're muted. Karen, you have to unmute.
The only thing I would say is this would probably be something that the general counsel would look at under the MV transportation. Is it covered under the contract? So it would depend on the circumstance, though. I agree with both of you.
So let me take another question from the audience, and then I have one based on what you've all been talking about, which is we're 5 months into the pandemic. So I do want to ask that, but I want to ask a couple of the questions that people have posed. So in New York today, does the panel believe it's appropriate for an employer to insist on remote bargaining only when the union offers a bargaining site where social distancing can be maintained? So basically, I think what they're saying here is the union has a place where you can do the bargaining and social distancing, and the employer says, no, it has to be remote. Is that appropriate? Michael,
Right.
You're the employer attorney.
So I honestly think sitting here today in New York, we're still, if you look at the New York Forward guidelines, if you look at what we're talking about for indoor meetings, I actually think that you're still in a mode where it is appropriate for either side to say, no, we're going to do this remotely. I think you're going to start seeing people try to do it more in person. It's going to depend because you need a space, right? This is the kind of thing that you have to deal with now, right? What's your occupancy level in that room, right? And you're supposed to cut the occupancy down 25, 30%, whatever the case may be, depending on the type of space you're in. I think it's very hard to find that, to have 2 rooms, to have the caucus rooms, to have the larger room. Maybe it's possible, but I think that you're going to have difficulty with both sides reaching an agreement to meet in person. And I also think you're going to have difficulty with people on either side being comfortable doing that. And until that happens, I think you're going to have, when it comes to the relationship, which is, ultimately the most important thing in making a deal and acting in good faith. I think both sides at this, now we're talking about today. A month from now, we may have a very different conversation. We may be looking at it and saying, no, offices are primarily open, not primarily closed, right? By the way, you said New York. Maybe this is a different conversation above Rockland County than it is down in the city and the immediate suburbs.
Allison, from the other perspective.
Yeah, I would mostly agree with what Mike said, and social distancing is one concern, but there are others too. What is the ventilation and HVAC system like in the building? What are the screening mechanisms in the building in terms of temperature taking and making sure no one's had a cough or a respiratory infection in the last however many days. So social distancing is one thing, but there are other safety considerations that have to be thought about as well. I tend to agree that as of today, July 22nd, 2020 in New York City, I don't think we're quite there yet in terms of insisting upon in-person negotiations. Whether it's the union or management who's doing the insisting, I don't think we're quite there yet.
Karen, would you do an arbitration in person?
I don't think so, but I'm going to be teaching in person. This is an issue that's coming up with the schools. And right now we're socially distancing, wearing masks, but that's bargaining, I agree with both of you. I don't think we're there yet.
Okay, so back to our remote bargaining. We have a couple of questions. I'm going to ask them together so that we can move this along. So this is a question about proposals and what do you do with proposals? So one person asks, can a trusted neutral be your hold the proposal sort of in escrow? So could you use that? Would that be appropriate in terms of proposals? Another person wants to know, sort of consistent with that, about how you can kick people under the table in remote bargaining. Can you use the chat to kick people under the table? Or do you have another idea, Allison, specifically mentioning you, to exchange proposals? Is there something that you recommend? So Allison, why don't we start with you?
Sure. No offense to Karen, but I don't think my clients would have much of an interest in spending money on an arbitrator to hold proposals. And I think the issue is less about, at least my experience, the issue is less about sort of who has possession of the proposals and more about how do we effectively get the proposals in front of everybody who needs to be seeing them as we're discussing them. My advice to my clients and what I've been trying to do in bargaining in terms of proposals is to get everyone to agree to exchange them in advance. I think that is the most effective way of dealing with it when you're doing remote bargaining. Maybe it doesn't have to be a day in advance, maybe it's an hour in advance, but really just enough time so that everyone has it and people who want hard copies can print it out and so that you can, because a lot of times what you're dealing with is you've emailed it to somebody, they want to open it on their computer, but they're remotely bargaining with you on their computer. So how do they do that? And it's just the technology of it is not great at this point. So I am pushing as much as possible the advance exchange of proposals. I'm actually finding it to be very efficient, especially when we're talking about more limited time in our bargaining sessions. To do more work away from the table is I think the way to go, and that includes exchanging proposals. In terms of using the chat function, I am a very strong, I have very strong negative feelings about the chat function. I think there is so much danger in accidentally chatting with the wrong people, wrong time, with the wrong things. I advise everyone not to use the chat. Most people have, phones, smartphones, and can get texts during bargaining. That's generally the way we go. When I have a small enough bargaining committee, I generally form sort of a group text at the beginning of the negotiations so we can communicate while bargaining is happening, and I use that as the kicking someone off the table. I've sent many texts saying like wrapped up, but we're doing the best we can in these circumstances, and I think the chat function is it's a major accident waiting to happen in my opinion.
Yeah, Michael, before you begin, yeah, sure. It's that special time where I tell everybody what their code is. The code is ILR 1948. And for those ILRs in the audience, this is the year the New York City office of the ILR School Extension Division was opened. So it's ILR 1948, and please, on your evaluation form, we need the letters and the numbers. Thank you very much. Michael, I'm sorry to interrupt you.
Okay, go red for any plug for the ILR School. I was going to say was one of the things that reminds me is that is dealing with the technology in remote bargaining. One option you can use is screen sharing. That does work sometimes. Shorter proposals, particularly. So if you have an opportunity, you taking advantage of the opportunity that you have a screen that you can share and everybody can see the same thing at the same time. That's one thing to think about. The other thing to think about is if you are the host of a Zoom, WebEx, Skype, whatever, is canceling the record function, right? One of the things, nowadays everybody can record things on their phones, but the board has been very clear that recording bargaining sessions is inappropriate without permission of both sides. Everybody has that ability to hit that record button. I know when I started doing this, it was the first couple of sessions, both sides, there's like the vehement agreement, right? Nobody hits record, you turn off the recording, but that doesn't always happen, meaning just the button doesn't actually go away sometimes. So highly recommend having that agreement with people, because the technology can help us and it could hurt us along the way too.
And that's true of the chat function too, which is, it's automatically, at least in some of the platforms, what you put in the chat is automatically saved, and whoever's hosting the bargaining session can forever have access to what is said in the chat. So another reason not to use it.
I just want to add something that was very coincidentally, I was teaching last semester collective bargaining, and it was a simulated collective bargaining class. And boom, we now had Zoom. What were we going to do? It was so interesting. I set the groups up into separate groups, and they used the breakout sessions to discuss it amongst themselves, which is one way we were on Zoom. The other thing is they would text each other while they were talking, even though they weren't in the same room. And then finally they shared sort of what Allison is saying. They shared their proposals and they made the changes together, I guess, in Google Docs. And so it worked out very well. And it was a great lesson for them how to bargain, and most of them bargained contracts, just coincidentally.
So somebody else has a question about sidebars. How do you handle sidebars in this kind of Zoom environment? Michael?
So, and Allison can tell you, because we did this. I mean, when you get toward the end game, it's a really complicated problem, right? Because we all know when we're bargaining, you may want to talk to the lead negotiator on the other side. You may not want everybody to know you want to talk to the lead negotiator on the other side. And the number one thing you lose in remote bargaining is the opportunity to catch that person while they're going to the bathroom, okay? Or whatever else they're doing as you're taking a break, right? And walk around the hall with me, right? That doesn't happen anymore. So how do you do it? Hope you have that other person's cell phone number, that other person's email address. I did a deal, we closed a deal, it's a different deal. And there was a point within an hour, I was on the Zoom, emailing, texting, and eventually just on the phone with the other side's counsel, right? I mean, you could break off into your own separate video conference if you wanted to. I wouldn't use the Zoom breakout rooms because everybody knows you're going, right? But there were times when we were both in caucus and I was calling the other side. It's kind of the same thing, but it's not. And you just have to work your way through it. But it's really about, if this is going to work, if you have an extremely adversarial relationship, I mean, like if you can't talk to each other, you can't talk to each other. I mean, it's just the obvious. You need to be able to have enough of a relationship to at least get the cell phone number and be able to text, email, and maybe pick up the phone and have a side call.
Allison, your experience?
Pretty similar. I mean, I think in this way, remote bargaining is not different than non-remote bargaining, which is that it's very relationship dependent. And if you don't have a relationship with someone that you can have an off-the-record conversation with in a hallway, it's going to be a lot harder to get a deal done. And the remoteness of this makes it even a little bit harder. So, and if you've only been engaging in remote bargaining, it's harder to get to the place where you have that relationship. All of that is true. I think the way you have to do sidebar conversations is similar to what Mike said, which is like, you're going to just have to do it by telephone, and you're going to have to put a pause to your remote bargaining, and you tell your committee what you want to tell your committee, or what you don't tell them what you're not going to tell them, and you have to use judgments the same way that you do when you're in-person bargaining, and you absent yourself and you get on the phone. It's not ideal, but it's doable.
And one of the hardest things about that just is frankly for you to explain to your own people where you're going or why you're doing it, right? I mean, I had an example, I won't obviously get into the substance of it, where I was trying to make very clear I needed to talk to the other side before the other side's lead counsel before I could make any other comments about this. And somebody on the committee, not the lawyer or not the lead spokesperson, was like, well, why won't you answer us? Why won't you answer us? Why won't you answer us? And the union's counsel just couldn't kick under the table. It's the same idea. Couldn't say, just wait. You couldn't give the hand. It's complicated. It's very difficult, but we make our way through it.
So now we have a bargaining question, not a remote bargaining question. So the question involves an employer, and I assume the question doesn't say it, in a collective bargaining relationship that at the beginning of the pandemic, they gave bonus pay, hazardous duty pay. And now, and I assume also this is New York City, we're in phase 4, or we're in upstate New York where the phases have moved even more quickly. And now the employer wants to withdraw that pay. May the employer unilaterally withdraw that pay? Does the employer have to bargain about the decision to withdraw that pay? Allison.
I think they have to, I think it depends what the agreement was in the first place for the hazard pay, right? If there was an agreement that said we're going to pay hazard pay for 60 days, then at the end of the 60 days, they can stop it without bargaining. But if it's just we're agreeing to pay hazard pay, and that's now the new status quo, and if they stop, I think that's a change that they have to bargain about.
Yeah, I mean, I think, again, it's going to depend on whether that happened by agreement or whether it happened unilaterally, whether or not I think if you created a practice, I think the circumstances that existed are relevant there. I think that, again, so there's a lot of factors there. Clearly, if you had an agreement that said during the COVID crisis, we're going to pay hazard pay for everybody who comes into work and stop, you're going to have an issue. You're going to have to bargain out of that. So, to have some resolution that the crisis has ended, so to speak. If you just did it unilaterally to attract people to get them to come to work, I think you have more, again, depending on your contract language, I think you have more leeway to say that we don't think that continues any further.
Karen, you're muted. You have to unmute.
No, I know. I'm muting because I have dogs here who are barking sometimes. But seriously, I think that is actually coming up in a lot of retail stores. I've seen this where somebody's working at Target or Amazon or wherever, and they were given hazard pay, and now it's being taken away. So I wouldn't be surprised if there's going to be some charges filed. So, or they have been already, if the employer is not willing to bargain over the decision.
So we have another question, and it involves timing. And it involves you're bargaining over the decision. You know that the governor is going to be rolling back on the phases. And so now it's a question of, you do have some time to bargain about the decision and how things are going to go. How quickly do you declare an impasse and then go to implementing the decision that you need to make because of some change, and then you move over to effects bargaining? I'm sure this is not such a unique situation anymore. Any thoughts on this? Allison, you're shaking your head, then Michael, then Karen.
Yeah, I mean, I'm always wary of when people ask how fast can we get to impasse. Impasse is not about how fast we can get there. You're at impasse when you're at impasse. You're at impasse when you've exhausted bargaining. And I know that the board certainly gives employers more leeway when we're talking about exigent circumstances or decisions that have to be made within a particular time period. But I think that my concern is when people approach those kinds of negotiations with the thought about how quickly can I get to impasse, it raises the question of whether there's good faith bargaining there to begin with. And there absolutely is the obligation to engage in good faith bargaining over those kinds of decisions. So, my response to that is you get to impasse when there's nothing more to bargain about. It's not a timeline.
I mean, it's hard to,
Michael.
It's hard to argue with that aspect of that sort of recitation of what an impasse is. I think the difference is the question of the urgent issue, and really whether or not you have an urgent issue. Just referencing back to this general counsel's memo that was released earlier this week in the Mercy Health case, doesn't provide a lot of guidance, but what it does say is it's the general counsel's view that an employer should be permitted to at least to at least initially act unilaterally during emergencies such as COVID-19, so long as its actions are reasonably related to the emergency situation, right? So we're dealing with a world that nobody's ever seen. If something comes up and you need to make the change, you make the change, right? If you have time to talk about making the change, and it's a decision bargaining obligation, I'm assuming there is one here, I think you have to spend as much time as you have, right? If you think you have time to talk about it, you should. If you don't, I think you should be prepared to explain that to an arbitrator and the labor board that there was a reason why you could not. And I think you're going to, and look, in a lot of circumstances, COVID-19, I think employers and in other contexts as well, you're going to get a lot more leeway than you might in other circumstances.
Yeah,
Karen, something to add?
not really. I agree with both sides.
So in our last few
Like an
minutes,
arbitrator.
in our last few minutes, is COVID going to change labor relations forever? Are we going to see more remote bargaining even after the pandemic is over? What do you see coming down the road in terms of what's going to happen to our field, given what we're experiencing now during the pandemic? Michael?
Yeah, so it's funny. One of the first notes I had taken and never quite got to say earlier was, we were starting to do remote bargaining anyway before this. Like the technology was catching up to it. Having committee members in Washington, D.C. and California at the same time so that you could bargain together. But that said, I think there will be some more of that. But I think if you polled labor relations professionals, right, they're going to go back to that GC memo I mentioned from 2003. The minute we can get back in a room, right, we're going to want to get back in a room so that we can actually do deals the way we want. It's going to change. It's going to be different for a long time, but we're going to all try. I think we're all trying to get back to what we used to know.
Allison?
Yeah, I think that this period of time with remote bargaining has both shown us that we can do remote bargaining and shown us that in-person bargaining is preferable. So I think that we now know we can do it. We have the ability to do it, and there may be some parties that choose to do it more, especially when it involves a lot of travel. But I also think that it has really shown, to the extent that people doubted it before, I think it has really proven that meeting face-to-face in person, there really isn't a substitute for that.
Yeah, I would agree. And I know, Allison, these Zoom arbitrations are not something that people really want to do. And I haven't done one, so I tend to think it would be impossible. But the only thing that is true is not with respect to bargaining, but that more people now and more employers are willing to let people do remote work. That is it, but not remote bargaining.
Yes, and I think Karen, that is going to change very drastically in terms of a substantive issue in bargaining. I think we're going to see a lot of different bargaining over telecommuting, from home things.
Yes.
I'm thinking and I'm hoping that employers are going to be a lot more receptive to that. I think unions are. We have this now as an arrow in our quiver that we've been doing it, and everything's just fine. So I think we'll see different things in that.
Michael, you get the last word.
Oh, no, I was going to say, just to echo that point is, well, I think that the desire will be to get back to a sort of a more traditional standard way of doing labor relations. I think the topics will be very different, right? As they are every time something like this happens. I think safety issues are going to be different conversations, obviously remote work, but also thinking forward, force majeure clauses, right? Right. That's going to be, and everybody's, we talked about it earlier, how to deal with those kinds of things. What kind of unilateral authority do we have? Planning for the next crisis is going to change the way we bargain because there are going to be different kinds of proposals that need to get made by both sides.
That's a wonderful ending to this webinar. Planning for a future crisis. Thank you. I want to thank Karen and Allison and Michael for participating today. I learned a great deal from all three of you, so thank you all very much. I want to thank our audience, our participants. I know there are questions in the chat that we were not able to get to. I will try to answer some of the questions that I can, and if I need help, I know that I can count on Karen or Allison or Michael to help me with your answers, because I want to make sure that you get answers. I want to remind you to please go into the chat function and download the evaluation, put in the CLE code so that you can get your CLEs. And I look forward to seeing you on another webinar really soon. Thank you all very much and have a good day.
Thank you.
Thank you.
Bye, everybody.
Bye.